So if you're in the midst of a high conflict divorce or custody, you probably have moments where you think there's actually movement or progress. Not both. They're not the same. Movement and progress are not synonymous. And if you have an attorney, it's really important that you know the difference. That's what we're talking about today. Stay tuned.
Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Hi, it's Tracey Bee again, and you're listening to another episode of Self-Represented in Family Court. Today, I wanted to talk to you about if you have an attorney and the attorney is working for you, whether or not they're actually solving problems or just merely managing conflict perpetually. Because there is a difference. And the difference is going to be determined by the amount of legal fees you happen to amass. I've had people come to me and ask me over and over again, hey, is my attorney really doing the best they can for me? Are they making the soundest decisions? Are their choices really actually having an impact in the direction I want my case to go? How do I know? And those are all legitimate questions. Not every attorney wants to take your case to trial. Not every attorney wants to even push your case down the trial track, what I call the trial track. Some of them do. I notice that your case is worth settling, and very early on. And so whether they are or aren't, the discussion, especially when you broach the topic of settlement, shouldn't be ignored. Your attorney should not be pursuing litigation or pushing your case toward the trial track when you are insisting that they settle. And it's your call. It's one thing for the attorney to say, well, I think you can get more if, push forward. And it's my job to inform you of that, but it's still your choice. At the end of the day, it's still your choice, not theirs. And so, other things like, trying to keep the emotional chaos to a minimum. Some attorneys are good at that. Some are just at it. But, they should be at least not ignoring the emotional element or component of your case by dismissing you every time you express emotion. And, a lot of attorneys get compassion fatigue, just like judges get compassion fatigue. So sometimes it's hard to empathize with every little thing you think is a life-changing or life-altering incident or exchange or whatever. But they should not be flippant about it either. That's really, really, really important. So the other side of that, though, is when they're just conflict managing, where they're just maintaining, where they're just putting out small fires or letting the small fires fester or burn out on their own. What does that look like? It looks like constant reaction. You can react, but your attorney should not be constantly reacting to everything. And when I say react, I mean outwardly, externally, like reaching out to opposing counsel or reaching out to the guardian ad litem or reaching out to the judge. Everything should not be a reaction. Those reactions are costing you. Those reactions, not just in money, but in more conflict, more tension, more dissension. It's going to cost you in time, money, energy, because all it does is create more conflict. It escalates your case to being more high conflict than necessary. So when you're upset that your lawyer is not reacting to something or everything you said, you shouldn't be. Of course, you should use discernment, because if it's, an emotional incident or an urgent incident where your kids are put in danger or you're about to be arrested or you've been locked out, those are things that, yes, the attorney should react to. But if your spouse is late with pickup and drop off continuously, or they're late with paying support, or there's a disagreement with whether or not their paramour should be present in the house or at an outing or event that both parties are going to attend, those are not something that the lawyer should be reacting for every single time. Because a lot of litigants get upset that the lawyer does not reach out to opposing counsel or inform the judge of every little infraction. You don't want that, because in essence, all it's doing is escalating things. Most times, all it does is escalate things. It's not necessary. Emergency filings. I think this is like the biggest consternation in between litigants who are represented and pro se, is that they think everything is an emergency. Everything is urgent, especially when they have attorneys, and the attorneys know better. If they're filing emergency petitions every time you ask them to, or at your urging, that's a huge red flag. Huge, huge, huge red flag. But those emergency petitions, a lot of times they fall flat anyway. They fall on deaf ears. Even when the thing about family court, about family law, about high conflict divorce and custody particularly, is that a lot of times there is no right or wrong answer. There's the answer, there's the movement, there's the choice, there's the decision that's best for you, for your circumstances, for your situation, for your case. And so sometimes it's gonna look like the decision or the choice or the move your attorney made isn't the most aligned one. And sometimes it looks like they're not doing anything. So what you need to be aware of, though, is whether or not what they're doing is actually solving problems, or is it just managing conflict? The point is, your attorney needs to be solving problems. Short-term, long-term, they need to be solving problems. Not everything they're going to do is going to move the needle in the direction of solving the biggest problems or the most complex problems, but they need to be solving problems. So let's get into the difference between problem solving and just conflict management, or conflict maneuvering, or conflict maintenance. Basically the opposite of problem solving. What does that look like? Problem solving looks more like, okay, you go into the attorney's office and you have a whole list of issues, of things you want, of things you were advised to ask for, because I know you've asked people in groups, in social media, in person, hey, what should I ask for when I go to the attorney? What should I ask for? And they tell you everything under the sun. So them problem solving looks like them actually, number one, identifying with you the real issues, the key issues that are relevant to not just your case, but to your jurisdiction, your judge, to the law, to the procedure, etc. Another example of actual problem solving is them prioritizing things, right? Lawyers need to prioritize things. If you were a stay-at-home parent and the other spouse is a high earner and you need additional funds, you need support from the other spouse because you are a stay-at-home parent, that's probably going to be your major issue when you go to the attorney, when you're working with the attorney, is to get some temporary support in place. Is to figure out the logistics of where you're gonna live, how you're gonna pay bills. Those things, not necessarily continuing life insurance or ensuring that, life insurance premiums are paid. Yes, that's an issue, but it's not gonna be a priority. So when they prioritize your needs, not what they think, but what you tell them, and that's why you need to be very candid and discuss everything that's going on so that they can identify what takes precedence, what takes priority, especially when they know the jurisdiction, how it works, the judge, the other attorneys, the climate, the legal climate. Another thing is reducing unnecessary battles. Everything is not worth a fight. Everything, and I know a lot of you are angry, you're hurt, you're in shock, you're in denial, and so those emotions, they proceed. They take over and they say, you know what, I'm gonna ask for everything I can possibly get because I'm angry, I'm hurt. But the lawyer, when they're problem solving, they're always gonna work at reducing unnecessary battles, right? And that's one of the areas where a lot of litigants get taken advantage of by attorneys, is that they think every battle is worth fighting, and they pursue it. They give every battle their energy, their time, their attention, their energy. And all those are doing is running up your fees, running up your bills. So every battle, and you may not know that, but the attorneys know. Most attorneys know which battles are worth fighting and which ones aren't, which ones are worth actually pursuing to the end and which ones aren't, in addition to prioritizing, issue spotting, all those things. Another thing, that you can identify when the attorney is really actually problem solving is when they create leverage. As you're telling them things that you're disappointed in, or you see a repeated pattern, and they're actually using that as leverage. They're communicating with the opposing counsel, they're communicating with the judge what these things are, or they're not, but they're storing it. They're actually taking it in and they're not ignoring it. They're using it as leverage to negotiate, leverage to move the case forward, leverage to, get exactly what you want accomplished. They are creating leverage and they're using leverage strategically. Even positioning for settlement, that's big. Not every attorney is a litigator, because that is ultimately what you paid them for, right? To solve problems. The challenge isn't them solving problems. The challenge is you pinpointing, spotting when they're actually doing that or making effort to do that. Because on the other side of that, they could just be putting out fires, as I mentioned. Sometimes the choices or the moves they make don't do much more than prolong things, put out small fires, postpone things, ignore things. So it's your job to understand the difference. Not just understand it, but to be able to identify it. Because doing something is not always enough, especially when the meter is running, when the bills are just piling up, when they're adding up, those invoices are going up, and you don't really see the effort or the work or the progress that commiserates with the amount that you're actually paying the lawyer. So let's discuss the difference between what problem solving things look like versus conflict management or conflict maintenance or conflict prolonging. Okay, so problem solving looks like your attorney narrowing the issues. You're going to go to the attorney with a plethora of issues. You want support, you want the exclusive residency, you want specific rules in place for exercise and visitation, custody, sale of the home or not sale of the home, or you want items out of the home, you want a whole list, right? Because if you're like most litigants, you've asked around in social media, in groups and support groups, working with coaches, you've asked for a whole list of everything under the kitchen sink. And you're expecting that the lawyer is going to oblige you. The lawyer is going to say, sure, we're going to just put that out there and we're going to make all these demands. Well, no. If a lawyer does that, that's a first red flag, because lawyers, skilled, experienced lawyers know that everything under the kitchen sink some of it is moldy, some of it is not good, some of it is useless, needs to be thrown out. And so the same thing with the issues. Some of them are not important, they're not material, they're never going to be addressed. They're just random and they're not necessarily worth your time and money, because it's going to cost you to pursue those issues. So the attorney, a real problem-solving attorney, is going to narrow those issues down. And when they are familiar with the jurisdiction, the venue you're in, it's easier for them to do that because they know the judge, they know the process, they know the rules, etc. Another thing they're going to do is they're going to be able to identify what's a priority or not. If you've been a stay-at-home parent and now you're about to split and you need some sort of financial support and you might need a place to live and you might need something concrete about, visitation or parenting access, then the lawyer is going to prioritize, of course, financial support, because you've been a stay-at-home parent and you don't have an income, and so you're going to need that. So they're going to probably file a motion for temporary relief if there's no opposing counsel and cooperative soon-to-be ex that you can hash that out. And even still, a court order is probably the most preferred approach to that. They're going to reduce unnecessary battles, right? Everything is not worth your energy, it's not worth your time, it's not worth the money, right? And the lawyers, experienced lawyers again, are going to know that. They're going to say, hey, listen, I get it. There is a disagreement as far as this is concerned, but concede to that because it's not worth the fight. The judge is not going to give you that attention or that time. They're not going to entertain that. It's going to help things move along. They're going to be mindful of the fact that every battle is not worth your energy. It's not worth your time. It's not worth you paying for it. Right? Because you will pay for it, not just monetarily. You're going to pay for it with energy, with stress, it's just not worth it. And so that's what problem solving looks like. Trying to identify the battles that are really worth fighting and the ones that are worth just resolving, basically settling. Problem solving also looks like creating leverage, right? The lawyer should know some of the things when you tell them everything you're going to tell them, they're going to be able to identify what can be used as leverage. It may not necessarily have merit in court if you go to hearing or trial, but there's some things that you're going to explain to them or you're going to disclose to them about what's happened in the past and even what's happened up until this very moment that you're meeting with them or talking to them. And they're going to be able to identify what they can use as leverage to settle, leverage to negotiate, leverage to get something to move faster or to move along. So that's one key indication that the lawyer is really focusing on problem solving and not just trying to, perpetually manage conflict, because perpetually managing conflict is where the cha-ching, cha-ching, cha-ching just keeps going, never ends. How about settlement? Yeah. Most lawyers even the ones who are actually pro-litigation, who usually puts their cases on that trial track versus the settlement track, they should still consider settlement, especially at your urging, at your request. If you come to the attorney from the beginning, from the start, and you say to them, hey, I really would like to try to settle this case no matter what. I would love to try to get this case moving along because, one, I don't have time, I don't have the attention, I don't have the energy, I don't have the resources to fight. Then the lawyer should be really trying to do just that. Not without informing you of what that might look like, but they should still do. I've been hearing people really lately, especially, really complaining about lawyers who ignore their client's request for settlement. Your lawyer should not be ignoring your request for settlement. If that's your wish, that's your desire, then that's exactly what the lawyer should be doing. Now, the lawyer should be informing you of, what settlement might look like, how it may be unfair, how it may be disadvantageous to you, but it's still your ultimate call. And that is something that the lawyer, if they are listening to you and they're really trying to position your case for settlement, then they're really trying to problem solve. You really know that they're basically looking out for your best interests. How about understanding the judge? If they're explaining to you who your judge is, how your judge might rule, how your judge, may use certain words, apply the law or apply procedure, that's usually too. It helps because you know why? When lawyers keep you in the dark or they don't communicate these things to you, it's easier for them to move the case the way they see fit And it's not necessarily always to your advantage. Sometimes it's to their own advantage. So, but if they explain to you beforehand who your judge is, how they rule, how they handle their court, how they apply the law, how they interpret the rules of procedure, et cetera, then the transparency in and of itself is a green flag that they are really trying to problem solve and not just drag the case on and just manage conflict, just put out small fires. And so another thing is, a lot of the lawyers don't help you manage your emotions, but they should be giving you some advice and some guidance about how important it is for you to manage your emotions. The ones who ignore that is, again, setting your case up for escalation, for moving from low or mid conflict to high conflict to extreme high conflict to delays, unnecessarily delays and stalling and all of that. So if a lawyer just doesn't want to address anything about your emotional state at any time, that's usually not a sign of them being on the problem solving side, but on the conflict management side. So let's talk about what conflict management looks like. The opposite of problem solving is the conflict management, where they're just, like I said, putting out small fires, or just, doing the bare minimum, or just doing enough, if anything, to give you the illusion that they're actually problem solving. So they're reacting. It's one thing for you to react to everything, but it's another thing for your attorney. Attorneys are experienced. A lot of us get to the point where we become well-versed at certain exchanges or interactions or occurrences. And so we don't react. Now, of course, if this is your first divorce, you're going to react. You're more likely to react to lack of cooperation, fraud and deceit and all of that. But expecting the lawyer to do that, or when you see the lawyer reacting to everything that you say or you bring to their attention, that's not a good thing. Those reactions are, again, those are running up the toll, the fees. They're just piling up. And another thing is, the judges don't want to see lawyers react. They expect that from you as the litigant, but not your lawyer. A lawyer reacting to everything in front of a judge, a lot of times it cues the judge off as well. How about those emergency filings? Everything that happens that's urgent to you, you expect the lawyer to file something. No, that is a big red flag for a lawyer to say, okay, I'm going to file, and I'm going to file another one, and I'm going to file another one. Because we all know, if you've been in family law for as long as I have, we all know that those filings don't necessarily wind up or end up getting you any sort of resolution or any sort of action from the judge that's actually going to address the behavior of the other party. It's usually a waste of time. Why bother? I never understood why lawyers do that. They'll bring up the same argument over and over again. A lot of times it's because the client wants them to. No, to me, that's just not a good strategy. And if you're going to bring up the same argument over and over, you have to do it strategically. It has to be done strategically. When you see the lawyer doing that, a lot of times it's because they don't have anything else. They're not preparing your case. They're not strategizing your case. They probably don't even know your case. When you go to court and you hear them saying the same argument to the judge over and over again, chances are they don't know anything else about your case. And yes, you probably had 10 conversations between the last court appearance and this one, and gave them so much more new information, and they still don't know. They're still making the same arguments. That's usually just conflict management. That's usually just putting out small fires. How about the constant request for discovery? No motions, nothing, just constant request for discovery. The flip side of that, sometimes the lack of interest in pursuing discovery. When, initial discovery demands were made and the lawyer refuses to follow up. Well, sometimes that's strategic, but sometimes it's not. Sometimes pursuing discovery is strategic, sometimes it's not. So that's a tough one. That's one that you probably need to have the guidance of someone like myself, who's actually going to help you see things in context. But another thing is, constantly doing legal things that have no real consequence. It has no real motion. It doesn't really move the case or move the needle in the case forward. They're just doing things to, find reasons to bill you, or to, like I said, placate you or keep you silent, to make you think that, yes, they're really, doing something is not necessarily the best option. Doing anything is not necessarily the best option. Sometimes doing nothing is the best option. But there are times when doing nothing can be detrimental. So again, it's for you to understand that and to be able to discern that. How do you do that? Well, you should be proactive. If you're self-represented, you need to be on top of these things. You need to work with somebody who knows the ins and outs. But if you're represented by an attorney, then you need to be proactive. You need to be asking questions. You need to be meeting with them regularly. You need to hold them accountable. You need to be CC'd on document exchanges. You need to know the judge. You need to know how your venue works. You need to know. Just turning over everything to your attorney, expecting them to take care of everything, is suicide. It's not a good thing. It's not the best route for you to go. And I know a lot of people still defer to their attorneys because they trust them and they're paying them, but it's just not the best route. There's a financial aspect of that, as I mentioned. Basically, working with an attorney who's just managing conflict, who's basically just putting out small fires, who are just doing the bare minimum, that's usually one sure way to run up attorney fees, bills, invoices to astronomical amounts of money. Your case might have been able to have been settled a year or two prior, but here you are in year 4 and nothing seems to be happening, and you're already $100,000 in debt. There are some instances where, yes, that is, pretty justified. I still think it's foolish, especially if you don't have $100,000 in resources just sitting around. But if you do, and you are fighting over 7-figure estates and assets, then sure. But if you don't have that, then I just don't think it's wise to be accumulating 6-figure in legal fees when you don't have it. When at the end of it all, you're gonna wind up having to go move in with your parents, and you and your 2 children are gonna have to sleep on a sofa bed. I'll never understand why people do that. At some point, and I say that sweet spot is the $30,000 mark. At $30,000, you need to reevaluate things. You need to reassess things. You need to see if things are really moving. You need to see if anything can be settled, it can be resolved. You need to really figure out once you've been in your high conflict or mid conflict divorce, and you've been 6 to 8 months or 9 months and you're 30,000 in, that's the sweet spot for me. That's when, yes, you should be calling me, emailing me, reaching out to me and say, hey, I want an hour with you because I need to see if I should be spending another 30 or 50 or 100,000, or if there's something I should be doing right now to sort of wrap this up. And I'm going to tell you, I'm not going to give you legal advice, but I'm going to give you strategy advice. And it's a lot of times that's way more valuable. It's way more critical and important to have than legal advice. Legal advice is just going to tell you if the motion is appropriate, but the strategic advice is going to take everything into account. Your financial situation, your future goals, your long-term and short-term future goals, your family dynamics, your plans, all of that, your current health concerns, your work issue. When you're in family court, nothing is isolated. Everything is in context. Everything. It pervades every area of your life. So if you're at a position where you're questioning whether your lawyer is really problem solving, or if they're just really managing conflict, then it's time for you to say, wait a minute, let me reevaluate things. You may want to get another lawyer, you may want to settle, you may want to push forward, but you should really be at some point, again, 30,000 is a sweet spot. Of course, if you can do it before you get to 30,000, that's ideal. But for me, in my 25 years of experience, I realized the 30,000 is the sweet spot. Sometimes there are ways to switch your case from conflict management to problem solving. And you can do that when you work effectively with your attorney. At any time, you can start to shift the dynamic, the working relationship you have with your attorney. How do you do that? Number one, you look at your retainer agreement. If you have a retainer agreement, it's important that you know what's in it. What you can expect from them, what they can expect from you should be in your retainer agreement. If it isn't, please schedule a meeting, whether it be by phone or in person, to have that discussion with your attorney. Don't run to fire your attorney just because you're concerned that these things are not in your retainer or things are not. Have a discussion, have a conversation with them. That should always be your next step after looking at your retainer agreement. Have a very candid discussion about what your disappointments are, what your expectations are, your questions, your concerns. Have that discussion. You owe it to yourself, you owe it to your case. Then from that moment on, then you know what to expect from them, they know what to expect from you, and now you have some sort of strict guidelines, some strict frame of reference that you can go back to when if things happen to get off course again. But you should always start there. And then after that, maybe start to check in. Set aside a time where you can check in, whether it be weekly or bi-weekly or monthly. Have a time where you can check in. Ask them for a set day and time that you can have a brief discussion about what's going on, what's been working, what's not working, what the hiccups are, what the bottlenecks are. Have that scheduled time where you can discuss. And then also, if it comes up again, you can bring up what you're disappointed in, what didn't happen, what did happen. It also serves another purpose. Lawyers are going to treat you the way you allow them to. They're human just like everybody else. We're human just like everybody else. And it's human nature to do what you allow me to do. If you allow me to do something and get away with it, I'm going to keep doing it. So checking in, asking the questions, having those discussions is only going to make them regard you and respect you more and to treat you somewhat the way you're demanding to be treated, in a very respectful team player kind of way. So do that. That way it is possible to switch tracks from your case being just a conflict management type of thing to now the lawyer is going to be focused on actual problem solving, because now you're requesting accountability and transparency. And you'll see the difference. If you don't, then it might be time to consider firing them and moving on to another one. But you owe it to yourself, you owe it to your family, your future, to at least try. And just because I mentioned all those red flags about that shows you when the lawyer is just basically putting out small fires, it doesn't mean all is lost. You have the opportunity to change things around. If you want to talk to me about any of that, please feel free. We can do an hour strategy session where we'll discuss those things. We'll talk about your lawyer. We'll talk about some of the issues that you're having, some of the questions that you may have, the concerns. We'll talk about it openly, candidly. I'll tell you some of the things I've done. Some of those things that I mentioned, I've done when I was in private practice. I discuss those things openly with my clients. I do, because I want them to know that I'm not just guessing. I'm speaking from personal experience. So if you want to do that, feel free. The link is in the show notes. Schedule a meeting. Schedule one soon, especially if you're at that $30,000 mark that I mentioned. It's time. Let's talk. Anyway, that's all I have for you today. I hope this was helpful for you or anyone you know. Please, if you do, let them know to come and check out today's episode because it's going to answer a lot of questions and it's going to minimize the stress and the worry and the concern that you or they may have concerning your lawyer representation, the way your case is moving along. So anyway, thank you so much for tuning in. Until next time, take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.